Hi there, I'm Seb Maley from Qdos, and in this video we'll have a look at some recent updates from the Government and HMRC. Firstly, we'll start with a positive legislative change which will have a knock-on effect to IR35 and the off-payroll rules. When the reformed version of the IR35 rules were introduced in April 2021, they included a carve-out or exemption for end clients who were small companies. Doing this allowed the government to claim that the vast majority of businesses in the UK would be unaffected by the change, although in practice the vast majority of contractors actually work for medium or large companies. Nevertheless, there will have been many small companies and contractors who will have been able to continue operating under the old IR35 regime as a result of the exemption, the categorisation of which is based on the bandings set out in the Companies Act. This is obviously a different piece of legislation and governs, amongst other things, the type of accounts a company has to file. In December, a change to the company size bandings was announced with the aim of reducing the administrative burden on thousands of businesses. Small companies file simpler accounts, are exempt from having to have statutory audits and from filing a strategic report. So by increasing the threshold for becoming a medium company, many businesses will be absolved of these responsibilities. The change will take effect from April 2025, meaning any company who is currently classed as medium but would be considered small under the new thresholds can immediately take advantage of them. HMRC have confirmed that these new bandings will also apply to IR35 and off-payroll, which is good news and means 14,000 companies will no longer fall under the reformed version of the rules, and any contractors they engage can determine their own status. There is, however, a bit of a question mark over when the benefit of this will actually kick in, specifically for IR35 and off-payroll. Whilst the off-payroll legislation borrows the bandings used in the Companies Act, they are completely separate legislation, so not everything is mirrored. The off-payroll rules also require a tax year to be linked to a financial year which has been completed, meaning there is always a lag in applying a size banding for IR35 compared to the actual size in a financial year. We are hoping for some clarification from the relevant government departments in the next few weeks, and we'll obviously update you in due course, but the change remains a positive irrespective of when it actually kicks in. The second recent update is directly from HMRC and involves an update to their employment status manual, which they use as a bit of a bible for how status should be determined. Whilst the ESM is technically an internal manual for HMRC officers, it is published publicly and, in addition to public guidance from HMRC, is widely used as a reference point for advisors and taxpayers. It is important to point out that the content of the manual is very much HMRC's interpretation of case law and is certainly not legislation itself, but it helps to understand what HMRC's own views is of certain matters and perhaps how they will perceive a particular point in the event of an investigation. Over recent years, many status cases have gone through the tribunal system and several have reached the higher courts where judgments will set new legal principles and case law. Perhaps the most significant of these is the Supreme Court case involving PGMOL, which we've spoken about a lot recently and involves the status of football referees. The employment status manual is updated when new precedent is set, and HMRC have recently made several updates specifically in relation to the PGMOL case. These largely revolve around the issues of mutuality of obligation and control, two of the key determining factors used to set status. With mutuality of obligation, HMRC's view is that it effectively exists by default, and that this stance was vindicated in the PGMOL case, and that it is unlikely to be a factor that can be used as a defence argument in cases going forward. While there is certainly a counter view to that, the reality is that in an investigation, HMRC are likely to give any defensive argument centred around mutuality short shrift until new precedent is set. The area of control is perhaps more convoluted. The PGMOL case was naturally pretty unique in nature, with working practices which differ wildly from a more typical contractor or self-employed person. Many elements of the judgment have been used by HMRC, however, to reshape their stance on control, most specifically around the need to consider whether there is a framework of control in existence. Ultimately, this means organisations and contractors can't rely solely on what happens in practice. If a contractor provides a service and is not subject to control by their client, this is only one part of the equation. Now, more than ever, it is important to demonstrate that a client has no right to exert control, even if it isn't exercised in practice. This clearly takes things into theoretical grounds and adds extra layers of complexity when putting forward status arguments. It also means that written contracts are becoming ever more important. It's much easier to evidence the position on control if it's clearly documented in a formal agreement between the parties. The third change is again from HMRC, but possibly slightly less contentious, and provides guidance on ensuring compliance in labour supply chains. This was published in January and gives businesses some recommendations on how tax compliance should be managed when there is a chain involving a supply of staff or labour, along with some guidance and examples of what the risks actually are. The guidance naturally touches on IR35 and off-payroll, but is far broader in scope and also covers areas like the construction industry and umbrella companies where, as we know, further legislation is imminent. It's certainly worth a read for any party involved in labour supply, and really reinforces the need for a focus on compliance and a joined-up supply chain. We'll continue to update you on developments, so please subscribe to our channel to be notified, and we'll see you next time.